The courtroom in Fulton County, Georgia was silent as 17-year-old Evan Mercer took the witness stand. He spoke carefully, slowly, confidently. Over and over again, he repeated the same sentence. I was defending myself. According to Mercer, the confrontation with his classmate had escalated suddenly. He claimed the other student had threatened him and moved to attack. So he reacted, panicked, afraid. And in that moment, Mercer insisted, he had no choice. To many watching the trial, the story seemed believable. Mercer appeared calm and respectful, the kind of teenager teachers described as responsible and disciplined. He was a varsity athlete with a composed bearing and a direct, earnest way of meeting people's eyes when he spoke that registered as honesty. But investigators had discovered something Mercer did not know existed. A camera. Mounted high on the wall of the school hallway, above the row of lockers, angled to cover the corridor from corner to corner. It had recorded the entire encounter, every step, every movement. And when that footage was finally shown to the jury, Mercer's claim of self-defense would begin to fall apart completely. Because the video told a completely different story. By the time Judge Raymond Holloway addressed Evan Mercer for the final time, the words self-defense would carry no meaning at all. The victim's name was Jordan Price. He was 17 years old, a junior at Hargrove Academy in Fulton County, and he had attended the school since 9th grade. His teachers described him as inconsistent, a student with real ability who applied it unevenly, showing up fully engaged for the classes he found interesting and drifting through the ones he did not. His basketball coach said he had the instincts of a natural leader on the court, but needed to develop patience. His sister, who was 19 and had moved out of the family home to attend college in Savannah, said he texted her almost every day, usually something funny, usually something about whatever was irritating him at school or at home, and that she had not known how much she relied on those texts until they stopped. Jordan and Evan Mercer had been in the same grade for 2 years. They were not close friends and had never been. Their social circles overlapped at the edges in the way that happens in schools where everyone knows everyone, and most of the knowing is surface level and transactional. The conflict between them had begun online, the way most conflicts begin now, with a comment that landed wrong, and a response that escalated it, and a chain of exchanges that stretched over weeks until it had its own momentum, its own logic, its own sense of unfinished business. Their mutual friends had watched the deterioration and said nothing useful, which was the thing most people did when they watched that kind of deterioration, because there was no comfortable intervention, and the comfortable option was to stay out of it. By the time the school day began on the morning of the incident, the conflict had been visible enough that at least 4 students could later describe knowing something was coming. Not the specifics, not the weapon or the hallway or the time, but the general shape of it, the sense that Evan Mercer had been carrying something for days, and that the carrying was almost done. The hallway where it happened was on the 2nd floor of the main building, near the locker bay between the English wing and the gymnasium corridor. Students passed through it constantly during passing periods and used it as a throughway between classes. At the moment captured on the security footage, it was not a passing period. It was 3 minutes before the end of 3rd period, when most students were in class and the hallway was largely empty. Jordan Price had been in the bathroom and was walking back to class. He had a pass. He was not looking for trouble. He was walking back to class. Detective Aaron Delgado was assigned to the case on the afternoon of the incident. He was a 12-year veteran of the Fulton County Police Department who had worked school-related cases before and had developed, over those years, a methodical approach that started with the physical evidence and worked outward. He arrived at the school while paramedics were still on scene and stood at the edge of the hallway looking at the tape and the evidence markers and the stillness that descends on a place after something violent has happened in it. The hallway smelled of the industrial floor cleaner that schools use, and something underneath it that he recognized and did not name. Students had been cleared from this wing of the building. 2 teachers were visible at the far end of the corridor, watching. The school's assistant principal was near the stairwell, with a phone pressed to her ear, her face the color of someone who has understood something that cannot be undone. Delgado noted the camera above the lockers immediately. It was mounted high on the wall, angled down to cover the length of the corridor, a black dome-style unit that was visible if you looked for it, and invisible if you did not. He identified himself to the school's assistant principal and requested the security system room. The school's security director, a retired police officer named Frank Osei, walked Delgado to the monitoring room and pulled up the footage from the second-floor hallway camera without being asked. He had already watched it once, and his expression when he looked at Delgado as the footage began said everything about what it contained. Delgado watched the footage. He watched it twice. Then he asked Osei to save a copy to an encrypted drive and to suspend access to the original files pending a formal evidence request. Osei did this without hesitation. Delgado walked to the parking lot and called his lieutenant. "We have video," he said. "How clear?" "Very," Delgado said. He stood in the parking lot for a moment, looking at the school building. He thought about Evan Mercer, who had been interviewed on scene and whose account he had already heard. He thought about the account and what he had just seen on the screen. He said, "I need a warrant for the full system footage and the defendant's phone." He had the warrant by end of day. Outside the school, students who had been evacuated to the parking lots and the athletic fields were being loaded onto buses and driven home or collected by parents who had heard the news and driven to the school in a state of controlled terror. 2 of Jordan Price's basketball teammates had been together when they heard what happened. They sat on a curb in the student parking lot and did not speak for a long time. One of them sent a text to Kira Price in Savannah that said only that something had happened and she should call home. He did not know how else to say it. Kira was in her second class of the morning, a survey course on European history, and she saw the message during the break and felt the specific cold that comes before understanding. The forensic examination of the school's security system was conducted by a specialist from the county's digital evidence unit, a woman named Karen Feld, who had been doing video authentication work for 8 years and who had testified in 19 cases. She documented the recording system's architecture, the continuous recording setup, the automatic backup to an off-site server that occurred every 6 hours, and the timestamp synchronization with a network time source. She pulled the relevant footage from both the on-site system and the backup server and generated hash values for both copies, confirming they were identical. She documented the chain of custody from the moment of collection through the delivery of the authenticated files to the prosecution's evidence database. Delgado requested Evan Mercer's phone records and personal device through a separate warrant obtained the following day. The phone yielded a text message sent at 7:58 in the morning, approximately 40 minutes before the incident, to a contact listed under the name Kyle. The message read, "Going to handle the problem today. Done waiting." The message had not been deleted. Delgado sat with this message for a while before writing it into his report. He thought about the word handle. He thought about the word waiting. He thought about a 17-year-old who had made a decision before school started and then walked through his morning with that decision already in him, sitting in first period and second period and third period with the decision waiting, eating breakfast with it, driving to school with it, carrying it down the hallway of the building he had attended for 3 years, and then going to the second floor. He thought about what it meant to have that much time with a decision and to continue with it anyway. He thought about Jordan Price walking back to class with a hall pass and no idea. He thought about Jordan Price walking back to class with a hall pass and no idea. He did not write these thoughts in his report. He wrote only the facts. Evan Mercer was arrested at his home the following morning. He came to the door in a collared shirt, as though he had dressed carefully in anticipation of the visit, and he said, when Delgado explained the arrest, that he understood and that he needed to call his attorney. His mother stood behind him in the hallway and pressed her hand over her mouth. Mercer turned to her and said, calmly, that it was going to be okay. He said it with the particular confidence of someone who has already constructed a narrative and believes in it. Delgado noted in his casebook, composed, prepared, narrative already formed. The attorney Mercer's family retained was a man named Gregory Fields, a defense attorney with 20 years of experience in Fulton County who had a specific reputation for self-defense cases. He was methodical and aggressive in the way that the best defense attorneys are aggressive, attacking the evidence chain rather than the facts themselves, finding the procedural and interpretive gaps that allowed alternative readings of what the prosecution was presenting. He was not a person who gave up easily. He reviewed the security footage within 72 hours of being retained. He watched it 4 times. Then he sat in his office with the lights off for a few minutes before turning them back on and calling his investigator with a series of questions about the camera's field of view, the timestamp methodology, and the possibility of compression artifacts affecting the interpretation of the footage. His investigator reported back 2 days later. The camera's field of view covered the entire relevant portion of the hallway. The timestamps were authenticated against an independent server. The compression artifacts were negligible and would not affect any reasonable reading of the footage. Fields added the investigator's report to his file and began building the best defense the evidence allowed. The best defense the evidence allowed was limited. Fields knew this. What he had was character evidence, the 2 years of online conflict that established the context of a genuine and escalating dispute. The argument that a person who has been threatened repeatedly over a sustained period might reasonably perceive a confrontation as a threat, even when an observer might see it differently. He had the argument of imperfect self-defense, the claim that even if Mercer was wrong about the threat, his belief in the threat was genuine, and his response, while legally excessive, was not premeditated murder. He had Mercer's record as an athlete and student, the absence of a prior criminal history, the youth of his client. He would build what he could, but he knew what was on the footage. During his first consultation with Evan Mercer in the county juvenile detention facility, Fields sat across the metal table and looked at his client and asked him a direct question before anything else. "I need to know," he said. whether there is anything that camera does not show. Anything that happened before Jordan Price entered the frame. Any reason you had to believe at that specific moment that you were in danger. Mercer looked at him steadily. He had the athlete's habit of holding eye contact during uncomfortable situations. The trained composure of someone who has spent years in competitive environments where showing weakness is a disadvantage. "He knew I was there," Mercer said. "We had been going at it for weeks. He knew I was going to be in that hallway. He was walking toward me." "His back was to you," Fields said. "He knew I was behind him," Mercer said. "He was going to turn around and come at me." Fields wrote this down. He looked at what he had written. He looked at his client. "Evan," he said carefully, "the footage shows Jordan Price walking toward his classroom. His posture does not show awareness of your presence. His pace does not change. He does not turn around. He does not reach for anything. The footage shows you approaching him from behind and initiating contact before he has turned." He paused. "I need to know whether there is anything I am missing in that reading." Mercer looked at the table and then back at Fields. "He knew I was there," he said again. "What makes you believe that?" "Because we had been going at it for weeks. Because everybody knew there was going to be a confrontation. Because he texted me that morning and said I should watch myself." Fields sat up straighter. "He texted you that morning?" "Yeah." "Where is that message?" Mercer was quiet for a moment. "I deleted it." Fields looked at him for a long moment. "Evan, if that message existed and was deleted, the forensic extraction of your phone will have found it, or it will have found the deletion. If there was a message from Jordan that morning, the prosecution already knows about it. And if there was such a message and they have not presented it, it means the message was not recovered, which means the deletion may have been complete." He leaned forward slightly. "But here is what I need you to understand. If you deleted a message that might have supported your account, the prosecution is going to argue that deletion was consciousness of guilt, that you were erasing evidence that contradicted the image you intended to present." Mercer was quiet. He was doing the arithmetic of the situation, the same arithmetic he had been doing since the arrest, looking for the version that worked. "Tell me exactly what that message said," Fields said. Mercer looked at the wall. "It said something like, 'We'll settle this today.' Something like that." "That message sounds like a mutual statement of intent to confront," Fields said. "Not a specific threat. Not a warning of imminent physical danger." He set his pen down. "Evan, I have presented every argument the evidence supports. I will continue to do that. But I need you to understand that the jury is going to see the footage, and there is nothing in the footage that shows a threat to you. There is nothing in the footage that shows Jordan Price doing anything except walking. I can argue the context of weeks of conflict. I can argue the psychological weight of sustained threat on a teenager. But the footage is what it is, and the jury will see it." Mercer said nothing for a moment. Then he said, "Then argue that." Fields closed his notepad. He was going to build the best case available. He had 20 years of experience doing exactly that. but he was already thinking about the sentencing phase. The arraignment was held in juvenile court, but the prosecution moved immediately for adult certification based on the severity of the crime and the evidence of premeditation. Judge Raymond Holloway, who had been assigned to the case, granted the transfer after a hearing in which Fields argued extensively for juvenile court jurisdiction, and the prosecution laid out the evidence in summary form. Mercer sat through the transfer hearing in a pressed suit, with his hands folded and his expression controlled. He looked at the judge when the decision was announced and did not look away. Whatever he felt, it did not show. The trial began 6 weeks later in Fulton County Superior Court. The jury pool had been large and the selection careful. Achebe had taken his time with it. He wanted jurors who could separate the image of the defendant from the evidence. He wanted people who understood that youth and composure were not exculpatory. He wanted people who would watch the footage and trust what they saw. The courtroom filled from the first day. The Price family sat in the gallery in a group of 7. Jordan's parents in the front row, his sister Kira beside their mother, Jordan's basketball coach and 2 of his teammates behind them. The team had come every day they could, rotating around their own school schedule, and their presence in the gallery made the case feel like what it was: a school community trying to understand something that had happened in its hallways. Evan Mercer sat at the defense table in a dark blazer and the blue tie that his mother had picked out because she believed it made him look trustworthy. He looked trustworthy. He looked calm. He looked, to a person observing him from the gallery without context, like a young man who had been wrongly accused of something and was bearing the injustice with quiet dignity. This was the performance, and it was a good one. Fields had worked with him on it, not as deception, but as the practical management of jury perception, which was a distinction that helped Fields sleep at night and was largely irrelevant to the outcome. The prosecution's opening statement laid out the structure of the case cleanly. The prosecutor, a woman named Tamara Brown, who had been with the Fulton County District Attorney's Office for 10 years and who had a reputation for methodical, evidence-driven presentation, described Jordan Price to the jury in specific human terms before she described anything else. She talked about who he was. She talked about what he had been doing the morning he was killed. She talked about the hall pass in his pocket and the class he was walking back to, and the text message he had sent his sister 2 days before the incident that was ordinary and funny, and that neither of them had known would be one of the last. She let Jordan Price exist fully and completely in the room as a real and specific person before she made him into a case. Then she described the evidence. She described it systematically, starting with the investigation and ending with the footage. She said the word footage once, without emphasis, and moved past it. She would let the footage do its own work when the time came. Fields's opening statement was shorter and more urgent in tone. He described Evan Mercer's perspective with empathy and conviction. The weeks of online conflict, the escalating threats, the morning of the incident, and what Evan had known and feared when he walked into that hallway. He described imperfect self-defense with care, asking the jury to consider the difference between a calculated killing and a terrified teenager responding to a threat he genuinely believed was coming. He used the word fear 9 times in 15 minutes. He described Evan as an honours student, a three-sport athlete, a young man with no criminal history who had been pushed to a breaking point by a sustained pattern of online harassment that had followed him into every part of his school day. He asked the jury to consider what it does to a person to be threatened repeatedly, to carry that threat with them through the hallways of the school where they spend most of their waking hours, to reach a point where the body and the mind are operating under a constant low-level state of alarm. He asked them to hold that context when they evaluated every piece of evidence they were about to see. He did not mention the footage. The first witnesses established the factual foundation. The first responding officer described the scene. Then, Fields put two of Evan Mercer's teachers on the stand in the early portion of the trial, using the character evidence to build the foundation of the defense portrait. Mercer's English teacher described him as thoughtful and engaged. His track coach described him as a natural leader who other athletes looked to for composure in difficult moments. The coach said, when Fields asked about Mercer's character, that in 3 years of working with him, he had never once seen Evan start a fight or provoke a confrontation. Brown cross-examined the track coach briefly. She asked whether the coach had been aware of the ongoing conflict between Mercer and Jordan Price. The coach said he had known there was some tension between them, but had not known the extent of it. Brown asked whether the coach's assessment of Mercer's character had changed at all since learning the details of the incident. The coach was quiet for a moment. He said he was still processing it. Brown thanked him and sat down. Mercer watched his coach's testimony from the defense table with his familiar, composed expression. Internally, he was doing what he had been doing since the trial began, the constant arithmetic of impression management, tracking the jury's faces and calculating the effect of each witness, each piece of testimony, each exchange. He had done this his entire life in competitive contexts, reading opponents and environments and adjusting. He believed he was doing it well. He believed the coach's testimony had been effective. He believed the jury saw him as Fields had described him, a good student and a good athlete and a frightened teenager. He told himself the footage would not be as damaging as he feared. He told himself it could be contextualized. He told himself Fields was skilled. He had been telling himself these things for 6 days. The first witnesses established the factual foundation. The first responding officer described the scene. The medical examiner, a precise, grey-haired man named Dr. Gerald Stanton, took the stand on the second day and described Jordan Price's injuries in clinical terms that the courtroom received in silence. The wound pattern, Stanton testified, was consistent with an attack from behind, with the initial impact delivered while Jordan Price was still in forward motion and had not turned to face his attacker. There was no defensive wound evidence on Jordan's hands or arms. A person who had seen an attack coming and had time to respond would typically show evidence of attempting to block or deflect. Jordan Price had no such evidence. In your professional opinion, Brown asked, is the wound pattern consistent with a person who was surprised by an attack? Yes, Stanton said. The evidence is consistent with a victim who did not see the attack coming. Fields cross-examined Stanton on whether the absence of defensive wounds was absolute proof that Jordan had not seen his attacker. Stanton acknowledged that the absence of defensive wounds was a finding, not a certainty. He maintained that the injury pattern and the position of the wounds were more consistent with an unexpected attack than with a face-to-face confrontation. Fields pressed on the possibility that a person might choose not to raise their hands in a confrontation, might stand their ground without blocking. Stanton said this was possible. Fields sat down. The teacher who had seen Mercer searching the second-floor hallway before the incident testified on the third day. Her name was Ms. Patricia Gomez, a 10-year veteran of the English department, and she described seeing Evan Mercer in the hallway near the locker bay approximately 8 minutes before the incident, walking slowly and looking in both directions as he moved. She had noticed him because students were not supposed to be in the hallway during class time without a pass, and she had intended to ask him about it before being called back to her own room by a student with a question. She had not thought more about it until the police came. "Did Evan appear to be waiting for someone?" Brown asked. "He appeared to be looking for someone," Gomez said carefully. "Whether he was waiting or looking, I cannot say with certainty, but he was not walking purposefully toward anywhere. He was moving slowly and checking both directions." Fields cross-examined her on the difference between looking for someone and looking for a specific threat, and on whether a student who had been engaged in an ongoing conflict might reasonably keep watch in a school hallway out of self-protective instinct rather than aggressive intent. Gomez acknowledged the distinction. She maintained her description of what she had observed. The text message came in through Delgado's testimony. Delgado described the phone extraction, the message, and the timestamp. He read the message aloud. "Going to handle the problem today. Done waiting." He read it without inflection, in the flat, factual tone of a detective who understands that the words carry their own weight. Brown asked him to describe the context of the extraction. Delgado explained that Tyler's phone had been seized under warrant and that the Digital Evidence Unit had performed a complete extraction, including deleted message recovery. He explained that the text message in question had not been deleted and had been found in the active message thread between Mercer and his contact, Kyle. He explained that the phone carrier's records independently confirmed the message's existence, timestamp, and content. "Detective Delgado," Brown said, "in your professional assessment, how did this message affect the direction of your investigation?" Delgado considered his answer for a moment. "It changed the investigation from an inquiry into a possible confrontation to an investigation into a planned act," he said. "A message saying 'done waiting' suggests a period of deliberate waiting that preceded it. It suggests a decision had been made before that morning. When I read that message in the context of the security footage I had already reviewed, the two pieces of evidence fit together in a way that was consistent with premeditation." Fields cross-examined him carefully. He asked whether the phrase "done waiting" might have referred to Mercer's decision to stop avoiding Jordan Price rather than a decision to attack him. Delgado acknowledged that language could have multiple interpretations. He said that the interpretation he had reached was informed by the complete evidence in the case, including the footage. Fields noted for the jury again that the detective's interpretation had been formed after viewing the footage, suggesting the investigation had been read through one particular lens. Mercer had been braced for this moment. He sat very still at the defense table and let his expression settle into something resigned and slightly pained. The expression of someone watching their private words taken out of context, being used against them. He had practiced this expression. He had discussed it with Fields. Fields had told him that the jury would be watching his reaction to the message, and that he needed to appear neither indifferent nor panicked. Pained resignation was the correct register. Fields argued in cross-examination that the message was ambiguous, and that handling a problem could mean any number of things, from a planned conversation to a decision to stop engaging entirely. Delgado acknowledged that language could be ambiguous. He said that in the context of the investigation, he had understood the message in light of the other evidence in the case. Fields asked whether he had formed his understanding before or after viewing the security footage. Delgado said that he had read the message after viewing the footage. Fields noted for the jury that the investigation had been interpreted through the lens of the footage from an early stage. A student named Priya Nambiar testified that she had been in the hallway approximately 2 minutes before the incident and had seen Jordan Price walking alone and looking at his phone. She described his demeanor as normal. He was not agitated. He was not looking around. He had not appeared to be anticipating or seeking a confrontation. "Did Jordan say anything to you?" Brown asked. "He said, 'Hey,'" Priya said. "Just, 'hey,' and kept walking." Another student, a boy named Chris Weatherby, who had been at the far end of the hallway when the incident occurred, testified that he had seen the attack begin and had immediately run in the opposite direction. He had not stayed to observe the full sequence of events. He had been interviewed by police within hours, and his description of what he had seen was consistent with the footage, which he had not been shown at the time of his interview. A forensic specialist named Dr. Amy Park testified about the injury analysis and the trajectory of the attack. She described the angle and force of the initial wound in terms that required careful explanation for the jury, and which Brown walked through methodically, ensuring each element was clearly understood. The conclusion of Park's analysis was straightforward. The attack had been initiated from behind. The attacker had been moving toward the victim, not away. The physics of the injury were inconsistent with a person in a defensive posture. Fields challenged Park on the margins of forensic certainty and on whether trajectory analysis could precisely determine the attacker's state of mind at the moment of contact. Park agreed that forensic analysis described physical events, not psychological ones. She maintained that the physical evidence described an attack initiated from a position of approach, not defense. By the 5th day of testimony, the evidence had assembled itself into a structure that every person in the courtroom could see clearly. The character evidence, the threat messages, the teacher's observation, the witness testimony, the forensic analysis, all of it pointed in one direction. There was one piece of evidence left to add, and everyone in the room knew which piece it was. The jury had been waiting for it since the opening statement. Even Mercer had been waiting for it in his own way, calculating and recalculating, telling himself that the footage could be argued, the context would save him, that Fields was skilled and Fields had not given up. The digital forensic specialist, Karen Feld, took the stand on the morning of the 6th day and walked the jury through the authentication process with the thoroughness of someone who understands that a jury's trust in video evidence depends entirely on their understanding of how it was obtained and verified. She described the school's recording system in accessible terms. She explained continuous recording and automatic backup. She explained hash values and what they meant for the integrity of a digital file. She explained timestamp synchronization and how the camera's clock had been verified against an independent source. She explained chain of custody from the school's security room to the county evidence database. "Ms. Feld," Brown said, "is there any technical basis upon which a person could reasonably argue that this footage has been altered, edited, or manipulated in any way?" "No," Feld said. "The hash values match. The backup copy is identical to the original. The timestamp is independently verified. The footage is authentic and unaltered." Fields cross-examined her on the theoretical possibilities, the camera angle, whether the footage captured the complete context of the hallway, or whether events might have occurred outside its field of view. Feld acknowledged that the camera had a defined field of view and could not record what was outside that view. She stated that the relevant portion of the hallway, the portion in which the incident occurred, was fully within the camera's coverage area. Fields asked whether it was possible that something had occurred between the two students before either of them entered the frame. Feld said it was possible that events had occurred outside the frame, but that the footage could only document what the camera recorded. She could not speak to what was outside the image. Fields sat down. He had placed the seed of an argument. Whether it would grow into anything was another question. The gallery had been quiet and attentive throughout the week of testimony. The Price family sat in their row with the stillness of people who have been waiting a long time for something and are now very close to it. Jordan's mother, a woman named Diane Price, kept a small notebook in her lap and occasionally wrote something in it, small notes that no one else could read from any distance. Jordan's sister Kira sat beside her with her hands folded and her eyes forward. Jordan's basketball coach had come every day. He sat in the second row with the particular expression of a person whose work involves believing in young people and who is trying to reconcile that belief with what he is being asked to understand. Brown stood and told the court that the state wished to present Exhibit 38. Judge Raymond Holloway, who had been on the Fulton County bench for 14 years and who had a reputation for running the most orderly courtroom in the county, and for tolerating precisely nothing in the way of manipulation or delay, noted the exhibit number and directed the technician to prepare the display. He was a tall, deliberate man with close-cropped grey hair and reading glasses that he wore at the end of his nose, giving him the perpetual expression of someone about to look up from something important. He had been watching Evan Mercer throughout the trial with the methodical attention of someone taking inventory, noting each element of the performance and filing it. And he was very ready for what was about to happen. The courtroom lights adjusted and the display screen activated. The image that appeared was a hallway. The floor was institutional tile, the walls the pale beige of every school building in the country. Lockers lined the right wall. Fluorescent lighting gave everything the flat, shadowless quality of a space designed for function rather than atmosphere. The timestamp in the upper right corner read 10:47:23. The hallway was mostly empty. Before pressing play, Brown turned to the jury. "You are about to see the complete, unedited footage from the second-floor hallway camera covering the relevant time period. I will play it once at normal speed and once more at reduced speed so that you can observe each element clearly. There will be no narration from me during the playback. The footage speaks for itself." She nodded to the technician. At the 7-second mark, Jordan Price walked into the frame from the right side of the screen. He was wearing a grey hoodie and dark jeans. He was looking at his phone. He walked with the loose, unhurried gait of a person going somewhere they have gone 100 times before. He was not scanning the hallway. He was not looking behind him. He was reading something on his phone and walking to class. Several jurors leaned forward. The woman in the front row of the jury box crossed her arms and then uncrossed them, as though she could not find a comfortable position. A juror in the back row had stopped writing on his notepad and was simply watching. At the 22-second mark, Evan Mercer entered the frame from the left side of the screen. He was wearing a dark sweatshirt and carrying a backpack. He did not look at the camera. He did not look at anything except Jordan Price's back, which was perhaps 15 feet in front of him. His walk was different from Jordan's. It was purposeful and controlled in the specific way that an athlete's walk is controlled, the body moving with economy and direction. He walked faster than Jordan. He closed the distance in less than 5 seconds. Jordan Price did not turn around. His pace did not change. He had not heard anything, or if he had not yet processed it as a threat, had not yet had time to process it. He was still looking at his phone. At the 30-second mark, Evan Mercer reached into the pocket of his sweatshirt. Jordan was still walking, still looking at his phone. The distance between them was now perhaps 3 feet. In the courtroom, at the defense table, Mercer's hands had separated from their folded position. His left hand was gripping the table edge. His right hand was flat on the surface. His jaw was visible, the muscles working. The composure that had held for 6 days was not holding anymore. It was not a dramatic collapse. It was something quieter and more permanent. The specific stillness of a person watching something that cannot be unsaid. The footage played. The courtroom watched. Jordan Price never turned around. When it was over, the screen froze on the final frame. The hallway quiet again. The space where 2 people had been a moment before, now empty and still, except for what had happened there. The silence in the courtroom lasted longer than it had lasted for anything else in the trial. It was the silence of 12 people and a gallery full of observers, absorbing what they had just seen and measuring it against the story they had been given. The story about fear and self-defense, and a teenager who had no choice. The measuring did not take long. Brown said, "We will now play the footage again at reduced speed." The second playback was slower, and in some ways worse. It gave the room time with each moment. Time to observe Jordan's posture in fine detail. Time to see the specific angle of his head as he looked at his phone. Time to see the complete absence of any movement that could be interpreted as threatening or even aware. At reduced speed, Mercer's approach was visible in each individual step. The closing of the distance, the hand going into the pocket, the exact moment of initiation. Nothing that happened in those frames was ambiguous. Nothing required interpretation. The footage was simply true. At the defense table, Evan Mercer had stopped watching the screen. He was looking at the table in front of him. His expression had passed through several things in the past few minutes and had arrived somewhere that was not composure and not panic, but something between them. The look of a person who has understood something they have been avoiding understanding. Fields sat beside him and did not speak. Fields had watched the footage 4 times before the trial began and had known each time what it showed. Watching it in this room, with the jury's 12 faces reflecting the light of the screen, confirmed everything he had already known about where this case was going. In the gallery, Jordan's mother, Diane Price, had stopped writing in her notebook. Her hands were pressed flat on it, covering the page. Kira had not moved. The basketball coach had his head down. Brown said, "No further questions for this witness." Feld stepped down. The afternoon recess was called, and the court officer escorted the jury out. As they filed past the defense table, 2 of them glanced at Mercer. He did not meet their eyes. In the consultation room during the recess, Fields sat across from his client and let the silence last for a moment before speaking. "I need to address the jury's view of the footage in my closing," he said. "I need to know if there is anything I have not been told that might help me contextualize what they saw." Mercer was looking at the wall. He had not been looking at anything in particular for the last 30 minutes. "He knew I was there," he said. He had said this several times now, across several consultations, and each time he said it, it sounded slightly less like an argument and slightly more like something he was telling himself. "Evan," Fields said quietly, "I have presented every argument the evidence supports. I will continue to do that. But I need you to understand that the jury has now seen what they have seen, and I cannot ask them to unsee it. What I can do is ask them to consider the context, the weeks of conflict, the genuine fear you describe, the complexity of what it means to be a 17-year-old in the middle of an escalating dispute." He looked at his client steadily. "But you need to let me do my job now. Whatever you are holding on to, whatever version of this you have been telling yourself, I need you to understand that the jury saw what was on that screen." Mercer looked at him. For a moment, something in his expression shifted, the composure dropping away to reveal something younger and less certain beneath it. Something that looked like the beginning of a recognition. Then the composure came back, or the echo of it, and he looked at the wall again. Brown delivered her closing argument with the same methodical clarity she had used throughout the trial, walking through each piece of evidence in sequence, describing the cumulative picture they created. She described Jordan Price walking to class with a hall pass and no knowledge of what was about to happen behind him. She described the text message sent that morning and what it said. She described the teacher's observation of Mercer in the hallway. She described the forensic analysis and what it established about the direction and physics of the attack. And then she described the footage, not with drama, but with precision, referring to specific moments and specific details that the jury had now seen twice and would carry into the deliberation room. "Self-defense," she said, "requires a threat, a real threat, a credible, present threat that leaves a person no reasonable choice. The footage you saw today does not show a threat. It shows a boy walking to class, looking at his phone, unaware that anyone was behind him. It shows the defendant approaching him from behind with a weapon already drawn. There is no threat in that footage. There is only an attack." She paused. "The defendant told you he was afraid. The footage shows what he did with that fear. He used it as a reason to approach an unsuspecting classmate from behind and attack him before that classmate had any chance to defend himself. That is not self-defense. That is the opposite of self-defense." Fields's closing was the best he could make it. He argued the weeks of provocation, the genuine fear, the psychological weight of sustained threat on a teenager. He argued imperfect self-defense with care and conviction. He described his client as a human being of 17 years with no prior record and a genuine history of being a good student and a good athlete and a good person who had found himself in a situation that had escalated beyond his capacity to manage it safely. He did not argue that the footage showed what Mercer had claimed. He argued that the footage did not show everything, that it did not show the interior of a frightened teenager's mind or the weeks of fear that had preceded the moment it captured. He did not look at the screen. The jury deliberated for 2 days. They returned on a Friday afternoon with a verdict of guilty on the charge of second-degree murder. Mercer was still when the verdict was read. He had been still for most of the trial, but this was a different stillness. The stillness of a person whose narrative has just ended and who has not yet constructed a replacement for it. He did not look at the jury as they filed out. He did not look at the Price family. He sat at the defense table with his hands folded, the same posture he had maintained throughout 6 days of testimony. But the hands now looked different, the gesture of habit rather than calculation. Fields placed his hand on Mercer's shoulder briefly and said something to him. Mercer nodded once and did not speak. In the gallery, the Price family received the verdict with a collective exhale that was not quite relief and not quite anything else, but the end of a specific kind of waiting. Diane Price closed her notebook and pressed it against her chest with both hands. Kira sat for a moment and then leaned her head against her mother's shoulder. Jordan's basketball coach stood and looked at the floor. He stayed that way for a moment, and then he walked out of the courtroom without speaking to anyone. Mercer's mother, seated in the first row behind the defense table, was crying quietly. She had maintained her own composure throughout the trial, coming every day in professional clothing, with her hair arranged carefully, performing the dignity of a parent who refuses to let the world see her break. She was not performing now. She was looking at the back of her son's head, at the dark blazer she had brought him, at the neatly parted hair, and she was crying the way people cry when the thing they have been refusing to believe has arrived. Mercer did not turn around. The sentencing hearing was 3 weeks later. Jordan Price's sister, Kira, had written her statement herself at the kitchen table of her college apartment in Savannah over the course of 4 evenings. She read it to the court standing at the podium in a voice that was steady in a way that was clearly costing her something. She talked about Jordan calling her on a Tuesday afternoon last spring because he had heard a song she used to play when he was in middle school, and he wanted to know what it was called. She said he remembered the smallest things about her, and she had not told him often enough that she noticed. She talked about his laugh, which was too loud for most situations, and which she had spent years telling him to moderate, and which she would now give nearly anything to hear, in any room, at any volume, for any reason. She talked about the Sunday mornings when he was a little kid and used to come into her room and wake her up by sitting on her feet until she acknowledged him. She said she had been annoyed by it every single time, and she understood now that she had been wrong to be annoyed. She looked at Evan Mercer once, briefly, while she was speaking, and then looked away. She did not address him. She did not need to. When she finished and sat down, the courtroom was very quiet, and the quiet had a specific weight. Judge Raymond Holloway looked at his paperwork for a moment. Then he set it aside and looked directly at Evan Mercer. "Mr. Mercer," he said, "you are going to listen to me now." Mercer looked up. "For the duration of this trial, you asked this court to accept a specific story. You said you were afraid. You said you were defending yourself. You said that in the moment of the confrontation, you perceived a threat so immediate and so serious that you had no reasonable alternative to the action you took." The judge's voice was level and measured, neither raised nor softened. It was the voice of someone who has said difficult things many times and knows that the difficulty lies in the content, not the delivery. "I want to be precise about what this court has seen and what it means." He paused. The footage from the second-floor hallway of Hargrove Academy shows Jordan Price walking toward his classroom. It shows him looking at his phone. It shows him unaware of your presence. It shows you entering the frame from the opposite direction and approaching him from behind. It shows you reaching for a weapon before Jordan Price had turned to face you, before he had spoken to you, before he had made any movement in your direction. The footage does not show a threat. The footage does not show a confrontation. The footage shows an ambush. Mercer's head had dropped slightly. His eyes were on the table. You sat in this courtroom, and you looked at the jury, and you told them you were afraid, the judge continued. You are a skilled athlete who has spent years training your composure under pressure. You managed your expression throughout 6 days of testimony with the deliberateness of someone who understood they were being watched. You maintained that composure through the medical examiner's testimony, through the forensic analysis, through the witness statements, through the reading of your own text message in this courtroom. He paused. And when the footage was played, you stopped being able to maintain it. Because the footage did not leave room for the performance. It showed what you did, precisely and completely. And there was no version of the performance that could survive contact with those images. Mercer's hands were flat on the table now, pressed down as though the table required holding in place. You sent a message the morning of Jordan Price's death that said you were going to handle the problem and that you were done waiting, the judge said. I want to address those words specifically. Done waiting. You had been waiting. You had been planning. You had made a decision before you arrived at school that morning, and you carried that decision through your morning and into that hallway. Jordan Price was not a threat you encountered. He was a destination you had chosen. Holloway's voice had not changed in volume or tempo throughout this address. It carried the particular authority of someone who does not need emphasis because every word is carrying its full weight. You were 17 years old when you made this choice. The court has considered that fact carefully, as it is required to do, and it has determined that the severity and the premeditation of this crime warrant adult sentencing. The law provides a framework, and the facts of this case place you within it. He picked up the sentencing documents. The argument of self-defense has a meaning in law. It has a specific, precise meaning that has been developed over centuries of legal reasoning. It requires a genuine, reasonable threat. It requires that the person claiming self-defense not be the aggressor. It requires that the response be proportionate to the threat. Self-defense cannot exist when you are the one who started the violence. That is not a technical legal point. That is a fundamental truth about what the words mean. He looked at Mercer steadily. Jordan Price's sister stood at that podium and described her brother to this court in specific human detail. She described who he was and what he meant to the people who loved him, and what the world looks like without him in it. I want you to understand that what you ended on that hallway floor was not a problem. It was a person. It was a person with a hall pass in his pocket, and a class to return to, and a sister who used to play songs that he remembered years later. It was a person who was walking somewhere when you came up behind him, and he never saw you coming. The room was completely still. Evan Mercer, it is the sentence of this court that you be committed to the custody of the Georgia Department of Corrections for a term of 28 years to be served in a state correctional facility. This sentence reflects the premeditated nature of the attack, the use of a weapon, the defendant's age and prior record, and the profound and irreversible impact of this crime on Jordan Price's family and community. He set the paperwork down. Self-defense cannot exist when you are the one who started the violence. You started the violence, Mr. Mercer. The footage is in the permanent record of this court, and it says what it says, and it cannot be altered, and it cannot be argued away. Jordan Price was walking to class. You were walking toward him. Evan Mercer was escorted from the defense table by 2 deputies. He walked toward the side door with his head slightly down, the dark blazer and blue tie that had been chosen to make him look trustworthy, now just clothing on a person who had just been told exactly what he had done and what it would cost him. He did not look at the gallery. He did not look at the Price family. He passed through the door, and it closed. The display screen on the wall still showed the frozen final frame of the hallway footage. The empty hallway, the pale beige walls, the fluorescent light, the timestamp in the upper right corner. The hallway that had been the scene of something irreversible, and that now existed only as this image, this piece of permanent evidence, this record of a moment that could not be called back. The Price family gathered their things. Diane Price closed her notebook and put it in her bag. Kira stood and took her mother's arm. The basketball coach stood and said nothing, and let the family go first. The gallery emptied slowly, the way galleries empty after something has concluded. People moving carefully, as if the weight of the room requires care on the way out. Detective Aaron Delgado had been seated at the back of the courtroom for the sentencing. He stood and put on his jacket and looked at the screen one last time before walking toward the door. He had thought, driving to the school on the afternoon the call came in, that the cases with footage were cleaner. He had been right, and also wrong. They were cleaner in the sense that the evidence removed ambiguity. They were not cleaner in any other sense. There was nothing clean about what that footage contained. There was only the truth of it, preserved on a server, authenticated and verified, available to anyone who needed to see it, and unable to be erased. In the weeks after the verdict, the case was discussed in school districts across the county and beyond. Principals sent letters home. Counselors held group sessions. A school board meeting in Fulton County included a discussion of the district's existing security camera infrastructure and whether the coverage was sufficient and whether the footage was being properly archived. The case was cited in those discussions as evidence that security cameras could serve a truth-telling function beyond deterrence, that they could preserve a record of what actually happened in disputes that human testimony alone could not reliably reconstruct. Karen Feld, the digital forensics specialist, was asked to speak at a law enforcement training session the following spring. She described the authentication process she had used in the case and the importance of establishing hash value verification and independent backup confirmation before footage is introduced in court. She said the most common question she received from other investigators was about how to handle footage that was claimed to have been accidentally deleted or overwritten. She said that in her experience, when footage genuinely needed to be found, it was usually there. The question was whether investigators knew to look for it and how. Hargrove Academy updated its security camera system the following school year, adding 6 additional cameras in previously uncovered areas of the building's second floor and improving the automatic backup schedule to every 2 hours. The announcement was made in a staff meeting. Nobody said Jordan Price's name at the meeting. They did not need to. The court officer reached past the exhibit table and pressed a button, and the display screen went dark. The courtroom settled into the institutional quiet of a building that has finished its business for the day, ready for whatever comes next, carrying no mark of what had happened except the record, the transcript, the sealed exhibits, and the 28 years of consequence that had followed a 17-year-old boy out a side door in handcuffs, down a corridor, and into a future that looked nothing like the one he had expected when he had sent a text message on an ordinary Tuesday morning that said he was done waiting.